Well, hello there, you amazing, beautiful, wonderful people. Here we go. This is part two. You're looking absolutely amazing. If you're not subscribed to the channel, make sure you subscribe to the channel. Turn on notification bell so if you are interested in going through this FRANKS hearing denial document in small bite-sized chunks, you can get every single part so you can choose which bits you want to see, which bits you don't. Anyway, I'm going to get straight into the meat and potatoes as we've got a lot to get through. And again, I don't want these videos to be too long for you. But here we go. So this one we're going to be talking about. The defendant has not met his FRANKS burden on issues 310 eyewitness statements. This is talking about Dylan Mortensen. So in issues 3 and 10, the defendant challenges the probable cause statements insofar as they set forth DM's witness interview descriptions of things she heard and saw on the night of November 13th, 2022. Defendant claims that law enforcement failed to inform the magistrate that DM's accounts describing the suspect were variable, that she questioned her memory, and that she did not recognise defendant when provided with a photo of him after his arrest. Defendant also contends that law enforcement misrepresented statements made by Dylan Mortensen that would have demonstrated her unreliability. I think that's incredibly important, but we're going to make our way through the doc. That's the purpose of this video. These alleged false statements and omissions, according to defendant, were exculpatory and material. While defendant's challenge may fodder for cross-examination, it is not the proper subject for a FRANKS motion. Defendant's own proffer establishes that Dylan Mortensen's accounts, we'll call it DM, were remarkably consistent throughout her multiple interviews with law enforcement, and further, the probable cause affidavit, we'll call it PCA, are very consistent with her account. Second, DM's interview statements that her memories were fuzzy and dreamlike and may have been affected by being tired or under the influence of alcohol do not call into question her reliability to the extent FRANKS would require disclosure. Are you sure? Finally, DM's failure to recognise the photo of defendant is of no consequence given that the intruder she saw was masked. They could have drawn a little mask on it, I suppose, like forehead and is that the eyes? DM's accounts were consistent and accurately summarised in the exhibit as the draft exhibit A circulated by law enforcement included the following description of the statements DM made during her interviews and with law enforcement. Made statements during interviews that indicated the occupants of the King Road residence were at home by 2 a.m. and reportedly asleep by approximately 4. Well, that's a falsity, isn't it? How would she have known that they were asleep? Did she go and check on them? I don't understand that, how you can affirm that someone's asleep unless you're watching them. And we know that Canodal was on her phone and she'd ordered food. I don't get it. This is with the exception of Canodal, who received a DoorDash order at the residence at approximately 4 a.m. Stated she was woken approximately 4 a.m, but what she stated sounded like Gonsalves playing with a dog in one of the upstairs bedrooms. Now, we know at 4 o'clock the person who did this crime apparently wasn't in the house, so if she was heard playing with a dog, she might have been playing with the dog, which would, again, allude to the fact that she wasn't asleep. So were they asleep, weren't they asleep? There is issues there, but albeit small ones. A short time later said she heard who she thought was Gonsalves say something to the effect of, "There's someone here." A review of forensic records associated with a download of Canodal's cellular phone indicated she was likely awake and using the TikTok app at approximately 4:12, so she weren't asleep. DM stated she looked out of her bedroom but did not see anything when she heard the comment about someone being in the house. DM stated she opened her door a second time and she heard what she thought was crying coming from Canodal's room. Then she said she heard a male voice say something to the effect of, "It's okay, I'm going to help you." At approximately 4:17, a camera at 11:12 King Road picked up audio of what sounded like a struggle coming from off camera. The security camera is less than 50 feet from Canodal's bedroom wall. The struggle lasted less than 1 minute and unintelligible sounds can be heard from the camera. Stated she opened the door for a third time. She heard crying and saw a figure clad in black clothing and mask that covered the person's mouth and nose walking towards her. Now, what I'd say here, after she heard crying and saw a figure, so did these coincide? We'll talk about it later. Mouth and nose walking towards her. Described the figure as 5'10" or taller. Male, not very muscular, but athletically built with bushy eyebrows. The male walked past DM as she stood in frozen shock phase as the male walked towards the back sliding glass door, locked herself in a room after seeing the male. This proportion of the draft exhibit was incorporated in varying degrees into Blaker's exhibit. When these exhibit A's were submitted in support of search warrant applications, DM had sat for at least 3 interviews with law enforcement, 2 on November 13th and 1 on November 17th with Detective Gooch. Her description of the intruder was notably similar during all 3 interviews. White male, skinny, lean type 3, slightly taller than DM, 5'10", slightly taller than DM, and it says about 5'10", and would Brian Koberger be classed as slightly taller or substantially taller, much taller? Because Brian Koberger looks much taller than 99% of the people who he stands around. So slightly taller, that's almost saying pretty much the same height. I'd be interested to put Dylan Mortensen standing next to Brian Koberger. Wearing all black, wearing a mask that was covering his forehead and mouth, a voice she didn't recognise saying he was here to help. The intruder walked out or towards the backsliding door without saying anything to her. While she did not tell Officer Nunes that she noticed the intruder carrying a vacuum-type object in his hand. So did he have a vacuum type? What does she mean by a vacuum type object? So did he go in, kill everyone, and then fucking hoover up afterwards? Fucking, I don't know, do some cleaning? What would be the vacuum type object? Or I'm guessing they're going to try and say that this was perhaps, they thought that it was a bag that everything was being put in. She did convey the information to Detective Mary, and this vacuum type object is going to be where Steve Gonsalves gets the kill kit from. I'm assuming, in his hand. She did not convey that information to Detective Mary later. She did convey that information, so it was later on, as well as to Detective Gooch a few days later after that. She also told Detective Gooch that she remembered the suspect's eyebrows were bushy, but could not remember their colour. Likewise told Detective Mary she could not remember the colour of his eyebrows. More importantly, not only are DM's statements consistent with each other with regards to the intruder's description, they were accurately included by law enforcement in the Exhibit A set forth above. There is not one statement in the affidavits regarding the intruder that cannot be traced directly to DM's words. Consequently, defendant has not demonstrated an intentional or reckless false statement or omission of a material exculpatory fact with regard to law enforcement's recount of DM's description of the suspect. Yeah, but if she was drunk and couldn't remember, then it doesn't matter whether the information was consistent. It could have been consistently wrong. If you have weighing scales that are wrong, then you're going to stand on them and they're going to be wrong every time. But I don't get it. Do you know what I mean? Defendant also asserts that Exhibit A watered down DM's statements about hair and Kayla Gonsalves around the time of the homicides. According to the defendant, DM was unequivocal in her 3 interviews when she reported that at approximately 4 a.m. she heard Ms. Gonsalves walk upstairs with her dog before running back down the stairs saying someone's hair. In Draft Exhibit A, however, law enforcement represent that DM said she thought she heard who she thought was Gonsalves say something to the effect of "there's someone here," emphasis added. Defendant argues the addition of the word thought is false, and further, defendant surmises it was intentionally false to cover up the fact that DM was wrong about what she heard. Defendant points out that Ms. Gonsalves was killed in the upstairs bedroom where she was found the next morning, thus it could not have been her who DM heard running down the stairs at 4 a.m. Defendant contends that DM's misperception, had it not been covered up by law enforcement, could have cast doubt on her reliability and therefore probable cause. However, the statement statement challenged by defendant can read in two ways. That DM said, I think it was Miss Gonsalves, which is now defendant apparently reads it, and which he claims is inconsistent with DM's interview statements. Or two, that DM said she heard Miss Gonsalves, but law enforcement had reason to think it could have been someone else. When the statement is reviewed in context, the latter makes more sense. In their Exhibit A's, Detective Payne and Sergeant Blaker immediately followed up the challenge statement with the following. A review of records obtained from a forensic download of Canodal's phone showed this could also have been Canodal, as her cellular phone indicated she was likely awake and using the TikTok app at approximately 4:12. Payne, Exhibit A, Blake, blah, blah, blah. Through this examination, Payne and Blake are effectively conveying to the magistrate why they believe DM's statement of who she heard was questionable. Thus, the court cannot include there is anything false or misleading in this regard. But it does, however, prove that she wasn't 100% about stuff. And when she's saying that she was drunk or whatever, it does bring things into question. But again, in addition, even assuming it was a false statement, defendant has not established that it was an intentional or reckless attempt to hide DM's alleged misconception, or that her actual statement was exculpatory or otherwise material to probable cause. Consequently, a FRANKS hearing is not warranted with regards to statements in the relevant Exhibit A's regarding DM's account of what she heard and saw. There is no evidence law enforcement intentionally or recklessly omitted information bearing on DM's reliability or such omissions were material to probable cause. Defendant next asserts that the probable cause statements omitted important information bearing on DM's reliability. Defendant notes that DM qualified her interview statements on several occasions by questioning her memory of the event. For example, she told Detective Mary, everything was kind of blurry, like I don't fully remember it, I would say. And then a few days later, while recounting the events to Detective Gooch, DM stated, again, I believe I was also very drunk. I don't know how much of this is real. Like, I don't know if my mind was like doing whatever. I don't know any of it. Like, half this stuff, I don't know if it's a dream, it's real. I have no clue. She also said her memory was fuzzy and cloudy and she could not differentiate if anything is real or if anything is a dream. This information was not included in Exhibit A's. According to the defendant, this information was crucial to allow the magistrate to properly evaluate DM's reliability, and its omission was material and exculpatory. I do feel they should have put that in. I do feel that it should have been added. The law does not favour defendant on this argument. Probable cause is determined by examining the totality of the circumstances and making practical common sense decisions, whether given all the circumstances set forth in the affidavit before the court, including the veracity and basis of knowledge of persons supplying hearsay information. There is fair probability that contraband or evidence of a crime will be found in a particular place. Whether the hearsay supplier is reliable is dependent in part on their status. Unlike an informer from the criminal milieu, crime victims or witnesses are presumed reliable and may be relied upon without independent corroboration. That's bollocks in itself. I don't know. Despite this presumed reliability, police must always be alert to whether other facts which have come to their attention raise doubts about the veracity of the witness, i.e. that such facts might include a motive to exaggerate or falsify statements made to law enforcement, or when the hearsay supplier is a young child or suffers from psychological delusions. In such circumstances, corroboration is required to establish reliability. But that's like saying if a crime happens and you don't report it, then there is, and there's an 8-hour delay in contacting law enforcement, then there's enough time for you guys to get together and tell a story. And with such minimal detail as well, you're not going to get it wrong. Bit taller than me, dressed in black, just saw their eyes, carrying something in their hand. That's all I know. The rest is a bit hazy. Might have heard someone go up. It's not a story that you're going to fuck up, is it? But I'd say if you fail to contact law enforcement for 8 to 10 hours after a crime, and when the law enforcement get there, the house is full of people, Fucking yeah, I don't know. Despite right, so such facts includes motive to exaggerate or falsify statements. Which there you go, law enforcement, blah 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 blah. So let's jump forward here. However, this is not a burdensome requirement. The corroboration of even innocent minor details can support a finding of probable cause. And then it goes on to say this. None of DM's qualifications during her interviews reasonably placed her presumed reliability in dispute. She was a direct witness and was able to consistently articulate the details she remembered throughout each interview, especially as to the facts relied on in the search warrants, affidavits. Despite the fact that she claimed her memory was fuzzy, or that she felt like it was a dream, or that she was still intoxicated, further, even if her reliability were in question, I need to just interject here and say, so is there going to be anything about Bethany Funk here? Because if Bethany Funk says one thing and she's like, I'm not drinking, I didn't go out, I was proper sober, and I heard this or I saw this, that is going to blow Dylan Mortensen out of the water. And that's the issue here. Let's see if there's any mention of it. There was other evidence, including the Exhibit A's, that corroborated her account. For example, the security camera 1112 King Road picked up the audio of the struggle at 4:17, which coincides with when Dylan Mortensen stated she thought was crying coming from Ms. Canodal's room and a male voice speaking. It was shortly after this she opened the door for a third time and saw the suspect walk by toward the glass sliding door, which corresponds with the surveillance video showing the suspect leaving 1122 King Road at 4:20. In addition, law enforcement corroborated DM's description of the defendant through its vehicle identification efforts, which led investigators to defendant's driving licence information. The Exhibit A's note that the defendant's physical description was consistent with DM's account. See Payne Exhibit A, blah, blah, blah. Defendant has shown no objective indication that DM's interview statements were unreliable, particularly given the other corroborating evidence, and therefore no reason for law enforcement to include her qualifications in the affidavit. For this reason, it cannot be said that law enforcement intentionally or recklessly omitted the information. Further, the Exhibit A's inferred that DM was traumatised when they noted that she stood in frozen shock phase when she saw the intruder. This necessarily alerted the magistrate that DM memories were coloured by trauma and shock, which goes to the issue of her reliability that defendant targets in this motion. Finally, even had the Exhibit A's included DM's qualification to her memory, it would not have significantly undermined her credibility and would not have negated probable cause. It would be no surprise to the magistrate that a person experiencing what DM must have experienced would be shaken by what happened and would have questioned the reality of what she perceived. This does not render her unreliable. Additionally, the bulk of probable cause came from other sources, including the extensive vehicle identification efforts, which half of that's missing, and the car wasn't even deemed as being his. Thus, even if the magistrate questioned the reliability of DM's account, she had suffered grounds through other evidence to issue the warrants. In sum, defendant has not shown DM's various qualifications to her memory and material exculpatory facts that were intentionally or recklessly omitted, and that would have affected probable cause. It is evident from the applicable Exhibit A's that Dylan Mortensen's account was largely relied upon to establish the timing of the homicides and a general description of the perpetrator, not to identify defendant specifically. A statement on these matters were consistent with any perceived weaknesses in a memory may be fodder for cross-examination. They do not negate probable cause. Consequently, a FRANKS hearing is not warranted. Again, this is about that burden of proof and the probable cause. Much different than beyond a reasonable doubt, and that's going to be the issue here. This isn't beyond a reasonable doubt, but it's just enough to get you through, probable cause. And the last section here, as I'm conscious that the video's creeping up, DM's non-recognition of defendant is immaterial. Defendant also contends that the law enforcement failed to include DM's non-recognition of the defendant in Exhibit A's warrants of Frank hearing. During her December 30th interview with law enforcement, DM was shown the defendant's mugshot and asked by Detective Lake whether defendant was the person she saw in a house, and DM responded, "I have no clue. From from what I remember, I just remember seeing this figure that was more like the skinnier tone build and some mask on. I don't know if it was covering his mouth or nose, or below his mouth or nose. I just remember he was white, but I didn't know how he was white. I just know he was, and I knew he looked at me because of the bushy eyebrows. So again, we'll speak on this later in another video. However, the fact DM could not identify defendant is hardly exculpatory or material to probable cause. Again, it's about probable cause, isn't it? But it's going on to cite another case here. Her inability to recognise defendant unmasked is expected, particularly where her description as relayed in the Exhibit A described a mask that covered the person's mouth and nose. Thus, because her non-recognition is not material and exculpatory, defendant cannot demonstrate her failure to include this fact in the probable cause affidavit warrants a FRANKS hearing. Defendant has not demonstrated law enforcement omitted it intentionally or recklessly, nor has he shown how including the information would have affected probable cause. One simply cannot say that had law enforcement included a statement that DM, unsurprisingly, was unable to recognise defendant from a photo, the magistrate would not have found probable cause. A FRANKS hearing is not warrant. But again, this is like, and this will be the next video, the vehicle identification. But this is like, it's not about taking, compartmentalizing everything and using it on its own merit. This is the collective, isn't it? And that's when things add up and add up and add up, and you look at the whole picture, it's then that things hold more gravitas. Do you know what I mean? That's all right, pulling every single thing apart. But when you turn around and say, you're looking at someone, right? And someone's in the house and you stare them fucking straight in the eye and they're staring back at you. And then you look at a photograph, you're drawn to the eyes. So if you don't recognise the eyes, we recognise people's eyes all the time. You might not recognise anything else about them because when you look at someone, you look them straight fucking in the eyes. So that to me, the fact that she's looking at a photograph that's including the fucking eyes, which would have been the ones that she stared into, I think you would recognise them if they. But again, that's just me. I'm just speculating, spitballing. Anyway, that is the second part. Again, if you're up for listening to the rest in these more smaller segmented pieces, do make sure that you subscribe to the channel, smack the notification bell, share far and wide. And then we're going to come together collectively on Sunday and go over the whole lot about what we think, what's happening next. And there will be a little video later on today that just touches on Ashley fucking Butfield. Love you all. Mwah.